Let's just jump right in. In this explainer, we're diving into a shocking new regulation that has thrown global businesses into an absolute, inescapable legal trap. We're talking about a scenario where the standard, everyday playbook for international business has essentially been turned right against itself. For decades, following the rules was the safe, boring path, right? But what actually happens when the rules themselves are engineered to contradict one another? Let's figure it out. Picture this. You're a compliance officer sitting in a darkened office in Shanghai. You're holding two letters, and you suddenly realize something terrifying. Obeying one of these automatically makes you a criminal to the other. On your desk, one letter from your New York headquarters orders you to cut off a Chinese supplier purely because Washington has sanctioned it. The second letter, though, it comes from the law of the very country you're sitting in. There's no clever legal memo that can just wave this away. The literal paperwork of compliance has become a trap, leaving you with one impossible question: which government are you willing to defy? The trap is, honestly, incredibly clear. On the one side, under U.S. sanctions, cutting off a sanctioned supplier is just, standard compliance. But on the other side, under this new Chinese law, that exact same act of compliance is now a punishable offense. It's wild. If you cut off the supplier, you violate Chinese law. But if you keep supplying them, you violate American law. Let's trace exactly when and how this impossible situation came to be. Section 1. The April 2026 Shock. A rule book with no runway. Let's look at how this legal trap was built and how it just snapped shut on the global market pretty much overnight. So on April 7th, 2026, China's State Council dropped a massive new set of regulations focused on protecting the security of its industrial and supply chains. Now, security of the supply chain sounds super technical, maybe even routine, right? But lawyers who've actually pored over this document warn it is anything but routine. This legal instrument drastically expands the Chinese government's power to impose what it calls countermeasures against any action that it deems a threat to its domestic supply chains. And here's what's truly abnormal about this rollout. Zero runway. No transition period at all. It took effect the exact same day it was published. Normally, regulations with this kind of massive weight arrive with months for companies to adapt, right? Time to rewrite contracts, retrain staff, all that. Not this time. There was absolutely no soft launch. Legal teams at multinational firms literally woke up to find that a rulebook they had never even seen before was already actively governing their daily operations. Section 2. The Compliance Catch-22, a direct conflict. The crucial point here is understanding the actual mechanics of how obeying one country's law directly violates the others. Okay, so under the old world, steps 1 and 2 were just standard procedure. Suspending supply because of a U.S. export control rule was just compliance. But step 3? That is the new reality. These new rules legally redefine that exact same act as an offense inside China. If a foreign enterprise suspends supply to a Chinese counterparty because a U.S. or European sanction leaves them zero choice, they now immediately trigger enforcement risk inside China. The company's local staff and executives are suddenly treated as legally obligated to comply with Chinese countermeasures, even when that directly contradicts the company's own global compliance policy. Top global law firms use this exact phrase, direct compliance conflict, to describe the situation. Why? Because there is no gray area here. There is no lawful exit. Firms like Morgan Lewis, Mayer Brown, Freshfields, White & Case, and Sidley are all looking at this and realizing that the act of obeying one government's sanctions has quite literally been redefined as an offense. You just cannot lawfully satisfy both sides. Section 3, the human target, reaching past the logo. Now, let's transition from corporate liability to the visceral, individual threat this poses to actual people on the ground. Because this goes way beyond a simple corporate fine. The real enforcement teeth actually come from these new regulations working right alongside the PRC anti-foreign sanctions law to specifically go after local country managers and sales reps. These laws are designed so that the actual human beings who design, decide on, or implement a sanctions compliance measure are held personally accountable. We aren't talking about faceless corporations anymore. We're talking about people. The local reps of foreign companies can themselves be placed on a counter-sanctions list. Instead of some faceless corporate fine that gets buried on page 50 of an annual report, the actual person signing off on the compliance decision could face severe, highly personal restrictions. A regional manager who just signs the standard paperwork to cut off a sanctioned supplier could suddenly find themselves facing a travel ban, literally unable to leave the country. They could face visa restrictions or find themselves legally prohibited from transferring data. The compliance decision that once lived safely inside a corporate legal department now has a human being's name attached to it. It reaches right past the corporate logo and directly touches the individual. Section 4, the look-through rule, piercing the shield. Now, you might be wondering, how on earth are companies defending themselves? Well, that brings us to a mechanism that completely pierces the traditional corporate shield. All those architectural defenses that multinationals spent decades and millions of dollars building, things like layered subsidiaries and minority stakes, they are completely nullified by what's called a look-through approach. For a generation, companies built joint ventures and subsidiaries within subsidiaries precisely to contain risk, right? The idea was that a problem in one entity wouldn't poison the whole bunch. But under this new reality, there is no safe percentage. A complex corporate structure simply no longer shields you. Liability doesn't just stop at the entity directly sanctioned anymore. It extends to any organization that entity controls or even merely participates in. If a sanctioned entity sits literally anywhere in your corporate web, the exposure can flow through the entire web. Law firms are cautioning that the defenses global businesses have relied on for decades are essentially useless against a rule that is explicitly designed to ignore them. So much for that expensive army of corporate structuring lawyers, right? Section 5. Two sides, one trap. A geopolitical standoff. Let's step back for a second and impartially examine the broader geopolitical standoff driving this entire conflict. It's crucial to understand that both sides have a narrative that makes total sense on its own terms. Beijing views these regulations as a vital defensive shield to stop its supply chains from being weaponized by extraterritorial Western sanctions. From their perspective, Western sanctions have been conscripting Chinese firms into foreign policy, and these new rules are a necessary assertion of sovereignty. On the flip side, corporate analysts warn this creates a chilling, frankly impossible position for global business. They see a world where staff are coerced, and every routine compliance decision turns into a massive geopolitical gamble. Both of these perspectives exist simultaneously. A shield to one side is a trap to the other. Because there's no clean legal answer here, companies are scrambling to mitigate the damage. They're furiously mapping every Chinese counterparty to uncover hidden exposures before they explode into a crisis. Crucially, they're doing things like quietly moving decision-making power completely out of China, just so local staff don't have to personally sign those dangerous orders and risk ending up on a sanctions list. They're even rewriting contracts to include clauses for legal conflicts that literally didn't exist before April 2026. It's a scramble to survive in a landscape where the tool of sanctions has been absorbed and handed right back as a weapon. Which brings us right back to that lonely compliance officer at their desk. They are forced to navigate a world where the rules themselves have been set against each other on purpose. Obedience to one is literally defiance of another. The safe, boring path of compliance has quietly just ceased to exist. So I'll leave you with this provocative thought. When following the rules becomes the violation, what does compliance even mean anymore? Thanks for joining me for this explainer. Keep questioning the rules.